Good day, and welcome to our topic for this week. Today, you are joining myself, Nobukhosi Zulu, and Liesl Pretorius to talk about the controversial Hate Speech Act. While this act is not yet operational, it is already the law, and the president can sign it into operation any day now. In our conversation today, we will consider what can be done, even at this late stage. And just think about what can be done about this act, which arguably criminalizes constitutionally protected expressions, including religious expression. We will also discuss the importance of public participation in the lawmaking process and answering the question of what does meaningful public participation mean, and what are the potential consequences of Parliament failing to facilitate this meaningful public participation. Welcome, Liesl.
Thank you, Nobukhosi. Welcome to the discussion as well.
Thank you. I think to start us off, Liesl, what is the Hate Speech Act and why is this new act so controversial?
Well, this is a new law, relatively new law. It was signed in May 2024. And it creates a new statutory crime of hate speech. So previously, we had common law crimes, similar criminal injuria. We had a civil hate speech offense, but we've never had a statutory crime of hate speech. So there's something new for South Africa. And what this law does is that it criminalizes certain kinds of expression, and expression is more than speech. It could be gestures, it could be certain images or displays even. And the sanction, if found guilty of hate speech, can be the imposition of a fine and or a term of imprisonment for up to 5 years. So it's quite serious. Now, why is this act so controversial? Well, the definition of hate speech is very wide. And of course, the wider a definition is, the more it captures under that definition. It's like a wide net being cast, and the more fish it drags in. And what it arguably does is that it criminalizes expression that is rightfully constitutionally protected. And this includes religious expression. And of course, we need to understand that our right to freedom of expression is so wide that there are certain types of expressions that we might not like, that even may be offensive, but it's not hate speech as contemplated in the Constitution and as contemplated in international law. And of course, this act needs to align with the Constitution. It needs to align with international law. So as such, this act is a threat to religious freedom, because it will impact religious expression. It's a threat to freedom of expression in general, because there are other types of expression impacted by it as well, but our mandate is quite narrow, so we're focusing on religious expression. And because expression is a key human right, so it affects human rights, it affects democracy, because freedom of expression is also a cornerstone right of democracy. So very concerning in general. And also, what is concerning, even if you have a law like this, and there might be certain expressions that the law will not actually criminalize, because people are unsure, and because they might be afraid and they're not sure, they don't know, am I breaking the law, am I not breaking the law? People might start to self-censor out of fear. And that really is not something that you want in a constitutional democracy based on human rights and freedoms, because freedom of expression is so much needed for a healthy public debate.
Thanks for that. I think that's so true. And the fear of self-censorship is a big one, because it can directly impact how democracies function. But Liesl, some people would argue that the desires that Parliament had with this Hate Speech Act are good and justifiable. And, it's to prevent hate speech and this rhetoric that goes around the country to protect certain protected groups. But you are arguing that this Hate Speech Act is potentially a threat to religious freedom. Why do you see that? How do you see this act particularly threatening religious freedoms?
Yes, so before we get to religious freedom, I think people need to understand for SA's position. We're not in favor of hate speech. We don't condone hate speech. Our concern is that this act goes wider than real hate speech. And we don't want to see speech that is not, in fact, hate speech criminalized. So this act criminalizes expression, and under expression falls religious expression. And basically what the act does, it defines hate speech as any communication that is harmful or incites harm and advocates hatred against specific groups of people listed in the act that are groups against whom you can commit hate speech. Now, the problem with the hate speech offense as it is written is it's very vague, it's very wide. And in criminal laws, you want nice tight definitions so that we know what we're talking about, so that we know what is criminal and what is not criminal. And as we said, because it's a wide and vague speech that is lawful, that should be rightfully constitutionally protected, can wrongly be caught in its wide net, because there's a difference between hate speech and speech that you hate or speech that you dislike. Why is this definition vague and broad? Firstly, because hatred is not defined. Arguably, the quintessential element of the crime of hate speech is hatred, and it's not defined. Then the definition of harm, which is a key definition, also very wide, contains subjective and vague components. For example, emotional harm can be very subjective. Yes, our Equality Act contains emotional harm, but that's a civil law. We're talking about a criminal law. Bars should be set higher in criminal laws. And then we also have, in the concept of harm, or one of the types of harm is social harm, which is defined as anything that undermines the social cohesion of South Africa, which is a very, very broad concept. It's a very new concept. It's very difficult to say kind of where that starts and where that ends. Then we have a very long list of prohibited grounds. We have the ones in the Constitution. We have some of the ones that are in the Equality Act, but not all of them. And then we have some that are not found in either the Constitution or the Equality Act. And some of these grounds are more controversial topics, contested topics, topics with changing meanings, and then none of them are defined, such as gender identity, for example. Some people might not be sure what that means or what it doesn't mean. And you want, like I said, it's a criminal law, so you want clear definitions so people know what is expected of them. Then what this act also does not, what it does do is it criminalizes, or rather, let me rather say, it does not exclude private communications. So when the Constitutional Court considered the Equality Act, the hate speech provision in the Kwalani judgment, they specifically said that in the civil context, private communication should be excluded from hate speech. Now we have a criminal hate speech act, and private communications are not excluded. So that is concerning. In more general, looking at the act more generally, arguably it does not meet international law obligations that for protection of freedom of expression, and also for protection of religious expression, and in international law and the guidances that comment on these instruments suggests a very high threshold for criminalizing speech. And arguably, we believe that this act does not set that bar high enough as required by international law. And that's important. It's important for protecting freedom of expression, because you don't want acts to be abused against people. And then the act does have a religious exemption clause. But when you look at how this clause is worded, it's worded in a very circular way. So much so that it becomes self-defeating, offering very, very little protection. And what the bottom line is, all of this taken together, is that this act can be abused. So it's too wide. It's capturing speech that should be rightfully be protected. It can be abused. It can even be weaponized against persons of faith or people of other views, because it does not only impact religious freedom, but we focus on religious freedom. It can impact people of faith who are expressing sincerely held views based on their sincerely held religious beliefs on topics or issues that are controversial in the times that we live, such as marriage and sex and gender and sexual relationships, even though they express it in a way that does not undermine the inherent dignity and equality of any human being. Now, Nobu, you mentioned meaningful public participation. And there was a lot of discussions around the hate speech bill, and was public participation meaningful, etc. But let's start off with, what is meaningful public participation, and why is that so important in the lawmaking process?
Yeah, Liesl, I think something that's really important for us to remember is South Africa is now a constitutional democracy. It's not a parliamentary supremacy anymore. And so it means that the lawmaking process is done in partnership with the people that the parliament are governing. And that is what public participation is about, that you don't make laws about us without us. And so Parliament is the legislative branch of government, and it's under a constitutional obligation to facilitate this meaningful public participation in the lawmaking process. And this is democracy in action, and it's a direct way for the public to give their input on the laws that govern us in our country. And so the way in which bills, when a bill is drafted, it's considered in detail by the parliamentary committees, which act as our representatives, and both houses of parliament also vote as a whole during their plenary sittings on the versions of the bills that are adopted. And when a bill, which is at this stage, draft law, is considered by a parliamentary committee, that committee opens the bill for public comment. And this public comment is open to people submitting their written comments. And they generally, if it's sometimes you'll find that they'll do a nationwide drive where they hold public hearings and they invite people to come and they record what everybody has to say about this law. And sometimes people can be invited to come and present their submissions before Parliament as well. And so it's meant to really be a lengthy and engaged process where concerned parties on specific laws have their voices heard before these draft bills are passed into acts. And the committees, they're supposed to give serious consideration to all the input received when deliberating a bill. It's not just a tick box exercise. You receive our comments, you read them, you take into consideration what the people are saying they want out of the laws, and then you incorporate that into a next draft and a second draft. So if Parliament fails to ensure that the public participation is meaningful, meaning they're actually considered and incorporated the comments that they received, and that bill is passed and signed into law and it becomes an act, it may well be open to constitutional challenge in the court.
Yes, because and that just emphasizes how important public participation is. Because as you say, we live in a democracy and we need to participate and have a say in the laws that are applied in our lives. So Nobu, would you say with the Hate Speech Act, was the public participation meaningful? And if in your view it wasn't meaningful, what happens?
So around the hate speech bill, there were 3 different rounds of public participation. One from the Department of Justice and Constitutional Development, another one from National Assembly, and another one from the National Council of Provinces. So there were 3 different rounds of submissions that were made. And in total, they received an estimated about 150 to 200,000 written submissions. The public now we know that public participation is not a referendum. So we're not saying that whoever gets the most votes or has the most submissions, wins, and that all submissions have to be considered, because obviously that would make the lawmaking process a little impossible. But what we are saying is if you get about 200,000 submissions, proper weight must be given if there is such a large significant call for specific inclusions, exclusions, or amendments. And the department did heed to calls to include a religious exemption clause, which is good and necessary. And it is a sign that they did actually consider some of the submissions that were made. And with the exception to some minority MPs, Parliament, both at the National Assembly and the NCOP, they didn't really heed all the numerous calls to define some of the key terms, such as they didn't heed the call to define hatred, they didn't improve the definition of harm, they didn't improve any of the religious exemption clauses, as well as any other exemption clauses that exist. They set a higher threshold for criminal hate speech. They didn't heed the calls that they need to exclude private communications, and how they didn't try to reconsider the grounds or revise the terms of imprisonment, etc. And there's quite a few really serious issues that have been pointed that they didn't take into consideration that came from all these hundreds of thousands of submissions. And in the end, despite the very serious reservations and the mass public concern about the constitutionality, the bill was rubber stamped and it was just steamrolled through. And we do question, considering how serious the concerns are, we do question and worry about whether MPs actually were able to properly apply their minds to this. And after this process, the president was still petitioned. Senior religious leaders that represent, millions of South Africans petitioned the president. Unfortunately, that didn't avail any results, and the act was still passed. So the way we see it, we don't see that meaningful public participation took place with this bill, because it's not just to say that they received 200,000 comments, therefore there was public participation. The question is, were these submissions carefully considered? And so, because we do not see that these submissions were carefully considered, it does open up this act to a constitutional challenge simply on the procedural grounds, because Parliament has a constitutional duty to facilitate meaningful public participation, which we don't think that they did in this case. And I think, when we've considered all of this and we understand the context, Liesl, do you think that there's anything that we can do about this hate speech act now that it exists? And how can we protect our rights and freedom to express our religious beliefs?
Well, no, but I think there are a few avenues. The one is the wait and see avenue. And this is where you wait for an appropriate test case. Somebody who is arrested and prosecuted wrongly under this act. But this can only happen after the act comes into operation, because the act is already law, but it's not yet operable. But that can happen any day. The only thing it will take is for the president to sign a proclamation that's published in the government gazette. So that's the one method. The other one is proactive litigation. And this is where you bring the constitutional challenge on substantive ground, the actual content of the hate speech act that you have issue with, like the definitions, etc., and on the procedural grounds, the public participation aspect. And that proactive litigation, it can be initiated now, but it's very expensive and is likely to take many years, because you can approach the Constitutional Court directly, but you need leave to do that. And this might not be seen as an urgent case, which means you need to start in the High Court, and then you go to the Supreme Court of Appeal, or if you're lucky, you can go to, from the High Court directly to the Constitutional Court. So that's a long route, takes a lot of money. And then a third option, which I think is a good option, is an amendment bill, because this is already an act of parliament. So you can bring an amendment bill to change the act, but that requires political buy-in. But if the amendment bill route is taken, it's a more cost-effective way to deal with the problematic issues, and then it can be an opportunity to ensure that there is indeed public participation that is meaningful.
Thanks, Liesl. I think with all these things that are happening now, what is 4SA doing about the Hate Speech Act with all these options that you've highlighted?
Well, we're doing quite a couple of things. We have met with concerned peer organizations. So these are organizations that also focus on the protection of human rights, fundamental rights. Their focus might be a bit different from ours, because we focus on religious freedom and related rights, but there's some overlap. So we've met with them to hear their views. We've also met with our internal legal team and with our larger, broader legal advisory board. We've been meeting with members of parliament across the political spectrum, because we are apolitical and we are very willing to work with anyone who wants to uphold religious freedom. So we've had a couple of meetings. We will be having a couple of more meetings. And I think so far, the MPs that we have met with, the parties that we have met with, they are quite sympathetic to our concerns, because they understand it's not about, we are not against, we're not for hate speech. We don't condone hate speech, but we are concerned that this act goes broader than the Constitution and international law. And obviously, protecting freedom of religion and protecting freedom of expression, our democracy, is very important. We've been raising awareness and doing education amongst religious leaders and religious communities, because they will be affected by any curtailment of the right to religious freedom, addressing their concerns. And we've also been considering our options around, the litigation route on substantive and procedural grounds, but also the amendment bill option. So we've been quite busy with our work on the hate speech bill. Of course, this is not the only freedom of religion matter that 4SA attends to. We have many other matters. Nobukhosi, maybe you can tell viewers who want more information about 4SA and our work, where can they go to get that?
Thanks, Liesl. It does sound like we've been very busy, And I think it's so important for people to stay up to date with the work that we are doing so that they're able to support us. And so the first place where you can go to find out more about what 4SA is doing is to visit our website. Our website, we have all kinds of resources. You'll also be able to sign up for our newsletter, and you'll be able to get access to our contact details, where you are welcome to pop us an email and to share with us how you are understanding this work and how you can partner with us. We are also there on social media. You can visit our Facebook page and stay up to date with the work that we are doing there. And we do also remind our followers and our supporters to please remember to financially support the work that 4SA is doing. And this work is so important to our democracy and our right to express our freedom of religion. And so we do invite everybody to continue to partner with us. We thank those that have partnered with us, and we invite all new people to please come through, and you can find out all the details on how you can give to make sure that this work continues to go on our website and our social media pages. So thank you everybody for joining us today. For Faith and Freedom, it's Liesl and Nobukhosi.
This is Michael Swain of 4SA. Remember to like and share this video, and then click on the subscribe button to make sure that you never miss our video updates on vital religious freedom issues.